Contracts. A contract is an agreement between two people, called the parties, and that is intended to be legally binding. The parties are the offeror and the offeree. The parties can be physical people, like you, or they can be moral people, like limited companies. For a contract to be binding, there must be 1. Offer. There must be an offer from one person to another. If this offer is subject to conditions, they must be communicated to the offeree on or before the time the contract is made. In a shop, the shopkeeper treats, that is, invites you to make an offer for any goods on display. You don't have to observe the price ticket, although it is common practice to do so. 2. Acceptance. Acceptance must be communicated to the person making the offer. If the person accepting the offer tries to introduce entirely new conditions into his acceptance, this is known as a counteroffer. The person making the initial offer, the shopkeeper, can reject your counteroffer and also withdraw his initial offer. 3. Consideration. Both parties must provide consideration, which is a fancy way of saying that they must both get something out of the deal. It does not mean behaving fairly towards one another, and it has nothing to do with being fair and considerate in the normal everyday sense. If you go into a shop to buy something, the shopkeeper's consideration is the object, and your consideration is the money. 4. Intention to create legal relations. As a general guide, a business agreement will usually be taken by the courts to show an intention to create a legal contract, whereas a domestic or social arrangement will not necessarily be intended to be legally binding. The kids can't take you to court because you didn't give them extra pocket money that you promised them. 5. Legal capacity. Both parties must have full legal capacity. They must not be minors, that is, under 18, and they must not be of unsound mind or drunk. A minor, under 18, can buy essential supplies such as food, but he cannot, for example, book a coach, which is not an essential supply. 6. Lawful nature. The subject of the contract must be legal. For example, it would be illegal to enter into an agreement with another bus company to offer joint services, because this is not allowed under the Competition Act 1980. Formalities. Sometimes there are special formalities, such as when you buy a house. In this case, there must be a deed. In the case of hire purchase, the contract must be in writing. However, if no special formalities are needed, then a contract will be quite valid if made orally. perhaps by a phone call, or even by lifting a finger as at an auction. The problem is, if there's a dispute, proving who said what. Breach. Contracts can be breached, and the innocent party can claim damages, money, as compensation. Only if vital terms, which are called conditions, are breached, can the innocent party actually terminate the contract.